Who do you go to when the police do not listen to you? I have had hundreds upon hundreds of discussions with people from all over India and many countries across the world when they face any situation with the police, either as a victim or as an accused person. The only question that comes is, when the police are not doing anything, what do I do? Who do I go to talk to? And the answer almost always comes out to be this: when the police do not listen to you, you go and approach the court of the magistrate. When you have to take the matter to court, because the police can deal with the situation as they deem fit, and with a lot of power and a lot of discretion, sneaks in a lot of arbitrariness and a lot of bias towards whoever favors the police official. And that is why, to keep a control over the powers of the police given to them by the Criminal Procedure Code of the country, the Criminal Procedure Code also envisions a check on the powers of these police officials, that is, the court of the magistrate. Recently, an instance came up a couple of months ago when a client approached me and said that he has been accused of sexual harassment falsely, and the police official refuses to even give a copy of the FIR. Now, a lot of people don't know this, that almost all FIRs, that is first information report, almost all of them nowadays are uploaded online after the judgment of the Honorable Supreme Court a couple of years ago in the case of Youth Bar Association versus Union of India. And the Supreme Court clearly said that you must immediately upload the FIR. And if the accused person, in say sensitive matters, you are not uploading a copy of the FIR, even then the accused person at least is entitled to a copy of the FIR. Now, we know the judgment. We know that as a matter of right, even if it is not being uploaded online, we must be given a copy. But now when you go to the police, they turn a deaf ear. हमें जी नहीं पता, आप कोर्ट से ले लो. But how do you go to the court? What do you do? A lot of people don't know about this either. And I have seen, it is very sad, on a lot of occasions, advocates advise their clients to move an anticipatory bail application, even in the most trivial of matters where arrest is not required by the investigating officer, just to get a copy of the FIR filed against the accused person. That is not the right approach. I, in fact, started this video thinking about something else, but this is the flow, the continuity of the thought. You don't need to apply for anticipatory bail. So even in this particular case, sexual harassment itself is a bailable offense. And we knew that the client is not going to face any sort of arrest whatsoever. And that is why moving an anticipatory bail application is completely absurd. What we did do instead, apart from moving an application for monitoring of investigation for certain other purposes, which again the investigating officer was not helping out with, we also moved an application for supply of copy of FIR. And the moment this application was put up before the judge, and the learned public prosecutor was also there along with the investigating officer, the magistrate said you must immediately give a copy of the FIR to the accused person within the next 24 hours. And lo and behold, something that we had a difficulty of about 4 to 5 days of procuring when we went to the investigating officer, discussed with her all of these things, yet nothing was being done. Immediately we got a copy of the FIR in the next couple of hours. It was sent by WhatsApp to us. Another instance where the magistrate stepped in and helped us out. A foreign client was cheated in a scam operated in India itself. Now, when we approached the authorities in India to apprehend the accused person, the police say that the offense is not made out in India. The territorial jurisdiction of India is not made out because of the fact that the person who was scammed lives abroad, lives in the US. So we cannot do anything in your matter. And I tried to reason with them. We spent several weeks trying to explain to them. They say we'll talk to superiors. Superiors also turn a deaf ear. And ultimately we went to the court of the magistrate seeking registration of the FIR in the matter. And even then, the status report filed in the matter, the police say that this police station does not have the jurisdiction to investigate into the matter. That is why we are not proceeding in the matter. To which the learned magistrate then passed orders telling the police that you do indeed have territorial matter. I have examined all the uh, allegations in the complaint, and prima facie territorial jurisdiction is there with you. And now I need you to file a fresh status report in the matter, telling me what you are planning to do. And now the matter is sub judice. It will be taken up in a couple of more days. But these are great examples to show how, when the police are being unreasonable, in one example as an allegedly accused person, and in another example as a complainant, whenever the police are being unreasonable, this is the one person that you go to. Now, which magistrate do you have to go to? Every police station is earmarked to the court of one magistrate. In metropolitan cities, it is a court of the metropolitan magistrate. In other cities, it is the court of the judicial magistrate. So whichever police station is marked to this particular magistrate, that magistrate is the sole person who will ensure that the police do not get out of hand in your situation. The police are, of course, there to assist us, to protect us, but common knowledge in this country is that it hardly happens. And one of the biggest reasons is, when you give so much arbitrary power to the police, there is bound to be misuse. That is where a judicial officer's restrained exercise of judicial power comes in to assist all of us citizens on a regular basis. Whenever you face any difficulty with the police, the court of the magistrate is where you have to rush.